Hi, I'm Chris Levy, Technical Partner at Aquila Super. And next up in our bite-sized briefings to help sort of streamline the audit and make it go as smooth as possible, I just want to briefly touch on downsizer contributions, which it's not typically a topic that I have expected would hold up audits or cause issues. But look, it has had we have seen them come through, and it can be a bit, not a problem, but it can slow things down. Now, before I get into the audit issues with downsizer contributions, I just wanted to briefly point out, a lot of accountants are across what the eligibility rules of downsizer contributions are, and the benefits and whatnot. But I have seen a couple of instances where accountants and even advisors aren't fully aware of the rules. And the one that strikes me is there is a belief by some people that don't deal with this a lot, is that the property has to have been their principal place of residence for the entirety of their ownership, of that minimum 10 years that they needed to own it. Look, that's not true. It needs to, yes, at points, it needs to have been the principal place of residence. And the terminology that they use is that it needs to be able to satisfy one of the CGT exemptions for being a principal place of residence, not just in full, but partially. So what this means is that an investment property, or a property where they may have lived in it and then it became an investment property, or vice versa, that's just as eligible to be able to use these rules as a house that someone's lived in their entire, for the entire ownership period. So look, just be aware of that, because I have seen instances where clients potentially missed out or were going to miss out, until we had discussions with the with an advisor, and it opens the opportunities up for your clients a bit more broadly. Right. So anyway, look, as to the audit requirements, what some accountants think is that downsizer contributions are just like any other contribution. The package, the audit file or the working papers file comes through, and it's just, this is a non-concessional, this is an employer, and this is a downsizer, and we don't need to do too much to look at it. That's not the case. The ATO, in actual fact, have put out a sort of guide for SMSF auditors to say, look, you explicitly require you to check these things here. And so what do they want us to check? Now, obviously, there's a downsizer contribution form. I'd say about half of the files, the audit files we get, don't have that form in them. We do need to see that. And even more importantly, it needs to be dated correctly. And this is, you've really got to be careful with this. The rule is that the actual contribution into the fund needs to have been done around the same time or after the date of the contribution form. I've heard instances where the auditor gets the file, not me, thank goodness. Auditor gets the file where it's the date on the downsizer contribution is not just dated wrong, it's after 30 June. Look, that fails. It makes the contribution ineligible. So look, just be careful about that. We do need to check that. Now, what else? Look, we also are required to check eligibility, age eligibility, and as most of you know, there was a 65-year one, and then it went to 60, and then it's gone to 55. But yeah, we do need to check that as well. And we also need to check the trustee, just make sure that it can actually accept downsizer contributions. Haven't seen any problems now, but I think there are some poorly drafted deeds that might prevent it. The final check that we do, and look, this is not actually one that the ATO has sort of explicitly made a big deal about, but we are required I believe we're required as auditors to check, is that it's been done in the correct time frame, as in it's the contribution has happened within the 90-day 90 days of settlement, which is built into the law, and what evidence we need for that is ideally the settlement statement. Because I mean that's the core document. Some people are a bit funny about giving us that settlement statement. It's not obviously it's not a fund document. It's a personal document, and some people would feel iffy about giving us basically personal information. look, that's okay. There's probably going to be publicly available information, say, from the Land Titles Office saying, look, there was a transfer on this date. And we also obviously need evidence that it was your property, but that's okay. We just need to know, look, there was a transfer of the property and that the contribution was done within those 90 days. So we need to look at it, but yeah, you don't need to give a settlement statement if you don't want to. So look, that's basically it. Before I go, just one other thing too about the work test in talking about contributions. Look, again, most accountants are across the rules, but some of them still don't understand that even though the work test was banished, a year or so ago, it wasn't completely banished. It's still there for personal concessional contributions. If your client is aged over 67 and is making personal concessional contributions or wants to, they will need to meet the work test, and we will have to ask questions about that. So yeah, just be mindful about that. All right, I think that's everything. Thanks a lot.